All right, good morning, everyone. Court will resume with the September 15th, 2022 docket. And we're on YouTube or live stream. And we have Mr. Martinez and Mr. Ethemiu.
Good morning, Your Honor.
Good morning. You need to unmute Mr. Martinez.
Mr. Martinez client.
Good
Yeah.
morning, Judge.
Good morning. Which is your client, Mr. Martinez?
Elizabeth Garcia, Your Honor, the petitioner.
Don't see her yet in the waiting
Judge.
room. Yes.
I have some preliminary statements for the court.
Uh-huh.
May I begin?
Sure.
Judge, we were ready for Tuesday, but then on Friday, the case got reset to today.
Uh-huh.
And I'm flying out of town in about an hour and a half from Harlingen
Uh-huh.
on a prepaid trip just to go visit my grandkids up in Dallas.
Okay.
And Judge, this is kind of a serious case that began with a writ of attachment back in December 2019, and it was executed around Christmas of 2019, New Year's. And there's also an attorney ad litem in the case, Judge Cynthia del Bosque. So we've been having a lot of trouble in this case with the parties handling the situation correctly. And I would like to ask for a reset of 1 week, Your Honor, to next Wednesday or Thursday, so that Cynthia del Bosque can get back up to par in the case, and so that I can have the opportunity to have a hearing, because we don't have enough time today.
Okay, Mr. Ethemiu.
Yes, Your Honor. On this case, I just got hired this year, back in the spring. It's been going on since 2019. And I understand Mr. Martinez's dilemma. I'm going on a trip for the next 2 weeks myself. So, but the issue is that there have been no orders here. We're supposed to have mediation. They require they asked for mediation back in May. And then after the court approved that, they said we don't have no money to do mediation. So for the last 4 or 5 months, I've been trying to get a hearing because my client has not seen his child for over 7 months. So that's my main issue.
Judge, and my main concern is that we had to have a writ of attachment to get the child back when this case started out, because Mr. Green has a habit of taking the child to San Benito to his mother's house and not bringing her back. And we also really need to get Cynthia del Bosque back up to par in this case so that she can make a recommendation to the court, Judge. So I would ask for a continuance. If Mr. Ethemiu is not going to be available for a couple of weeks, maybe for 30 days, Judge. I'm not asking for much time.
I don't need 30 days. I can do it after the 29th.
After the what?
29th, September 29th.
Okay. Well, Cynthia del Bosque, how did she get in the picture here?
She's the attorney ad litem, Judge.
Was it because the court appointed her, or you guys decided to put her in there?
No, she was appointed back in
April 2021.
And has she done any work?
No.
Well, Judge, she's met with my client, but Mr. Green hasn't made himself available to her.
Well, I'm going to ask her then. I need to put her under oath and ask her what's going on in this case. There's already been a lot of time already. So I'll reset it, and it'll be what, after 29th?
Yes, Judge.
Submit an order setting hearing date, and I'm going to talk to Cynthia about this matter. I want to see who's dropping the ball, because that's going to matter to me more about who's not going to mediation and so forth. So be ready for give me an order setting it for another hearing, and be ready, guys. Okay.
So
Thank you, Judge.
Do we have a date, Your Honor, or we're going to get
No,
a
not
date?
yet. Just submit it. Be ready. Please be ready.
Thank you, Your Honor.
Thank you. May I be excused, Your
You
Honor?
all are excused. Have a great day. All right. That'll be number 7.
Number 6 and number 7.
6 and 7. Let's see, Mr. Abel Hinojosa and Mr. Roby Flores.
Good morning, Judge. Can you hear me clearly?
I can hear you clearly. You look like one of those airline pilots. And where are you going?
Yeah, Judge, I'm in the lawyer's lounge right now, so I don't want to.
Oh,
So I'm isolating the sound so I can focus on you, Judge.
okay, great.
I
And
think he's
Mr.
trying-
Flores is getting ready.
I'm
Yeah.
here, Judge. I think Mr.
Do we
Hinojosa-
bring in the parties? Are they here? Are the parties also here? Let me see.
No, Judge.
Oh, they're not around.
My client's there, Judge. She's in my office, though. She is there.
Okay, in your office. Okay.
Can we
Yeah,
just
my
take
client's
Darlene
are
real
in my
quick?
office.
She's got a quick announcement.
Oh, you know what? Let me get a quick announcement here by Darlene Bell. Just a real quick one here. Real quick one.
Oh, okay,
An
sure.
extension.
What number is it? Right here, number 12. Number
Yes,
12,
Yes,
Darlene Bell.
yes.
Okay.
Yes,
That'll
sir.
be, yes, ma'am. Good morning. You're here on the September 15, 2022 docket. And I have F32 14-22-4 in the matter of the marriage of Michelle Elizondo and Narciso Salinas. Yes, ma'am.
Yes, Your Honor, I filed a motion for continuance. I just got hired. Mr. Narciso actually didn't get served. They left the papers at his house, but he contacted me. He's on a rig in the ocean, Judge. I gotta wait for him to get back. And so we're
Okay.
asking for continuance. I did not believe, and I thought that Ms. Arispe had filed a Rule 11 agreement, but I guess she hasn't. We understood she was in an agreement as long as she got her TRO extended.
Okay, it'll be continued and extended, right?
Correct. That's my understanding of what we had agreed to.
Okay,
Judge.
who's
I
gonna
don't
be
know if
submitting the
we're
order?
on or not.
That's already submitted. Are we gonna need more than 14 days or is 14 days good?
Is 14 days gonna be good? Or will it still be out, ma'am?
It's gonna have to, Judge, we'll do it by Zoom.
Oh, it'll be Zoom, okay.
We'll do it by Zoom because if
Okay.
he's out in the rig, he's gonna have to do it by Zoom, but yeah,
Okay,
I mean.
Okay,
that'll
who's
give me
gonna be
time
submitting
to
the order?
prepare.
It's already on file.
it's already on file. Very good. Then that'll do it, Ms. Bell. Thank you.
Okay, when did the court extend it to,
I
Judge?
don't know.
Oh, no, we don't know yet. We're gonna find out this afternoon. We'll let
Okay,
you know.
all right, all
We'll let
right.
you know.
Thank you, Judge.
Yes, thank you, man. Have a great day.
You too.
All right, let's go back to Mr. Flores and Mr. Hinojosa. Gentlemen, you're here on number 6 and 7, F0048-20-4 in the matter of the marriage of Maria del Pilar Navarro and Jesus Navarro. All right, what do we
Yes.
have here?
Judge, it's Avelino Host. I have two motions before the court that are set for today only.
Okay.
The motion for the sworn inventory,
Uh-huh.
and that's based on Chapter 6.502 of the Texas Family Code, where the court can order a sworn inventory of the community property and separate property.
Mhm.
That's one issue. And then the issue, which should not be any objection, I'm assuming, is the motion for mediation in this case, Judge. I don't think there's objection to mediation, and I'd be requesting Lucia Thompson as the mediator in this case once it's ready to finalize, or once it's ready for mediation, Judge.
All right, Mr. Flores.
I have no objection to Lucia Thompson.
I'll put here Lucy Thompson. That's shorter for me to less ink. And
Can we prepare an order saying that the cost to be divided equally?
Of course.
1/2 each.
And,
You
and
got
on the, and on the inventory and appraisement,
Uh-huh.
Mr. Hinojosa's client just amended a pleading and brought in a third party.
We did,
if
Judge.
if you will. So the inventory is limited to Mr. Navarro, and as Mr. Hinojosa indicated, this is about separate community property. And as we all know, under the business code, this entity that is an Inc., say subchapter S, is not separate or community. And literally, they've just been brought into this lawsuit, and I will be representing the corporation, but we
And
have
if
not filed an answer yet because we're still reviewing the pleadings.
May I respond, Judge, to that?
Uh-huh.
The inventory and appraisement under 6.502 can include separate property. We are disputing that the LLC, which is named as, I do have it right here, Judge. It's part of the new suit that we did. The LLC McAllen Care Providers, Inc. is basically a part of the community estate. We dispute that it is separate property. We did file a motion for that, Judge, but that is not set for today. That is not on today's docket, but we did file a motion to that to include that as an alter ego of Mr. Flores' client.
Yep.
But Your Honor, for the 6.502 for
Uh-huh.
the inventory and appraisal, the court can also include the evaluation of the separate property. Their allegation that separate property, we're saying it's community property. We might as well basically get the value of every single asset that may be in dispute in this matter. It makes it a lot easier. Because then if the court finds, forgive me, Mr. Flores, if the court finds that the LLC is community property, there, we got the appraisal, we got the value. If the court says it is not community property, okay, then basically the court has made its determination, but the court can basically do evaluation as to separate and community property of the parties, Judge.
Well, Judge, first of all, an LLC, or in this case, the subchapter S, is not separate or community. By the business code, we can have that argument another day. I don't have a problem doing an inventory and appraisal of the separate community, but the LLC, it's an entity. It's not separate or community. That'd be like him saying, Mr. Navarro has an LLC interest in Apple, and so now Apple, you're going to have to give us an inventory. No, you don't. You just started this lawsuit against Apple, and in this case, McAllen Care Providers. It is a separate entity. This separate entity is not separate or community under the business code. There are certain things that may be considered as community, such as draws or payments that are made, but those are going to be disclosed in the tax returns. So it is premature. It is premature to say that McAllen Care Providers, which is a separate entity, has to give up its value to a party, a third party. They've named them as a third party, just because they say, we think and we believe it's an alter ego. We're not there yet. We're not there yet. We're not even close to it yet. We haven't even filed our response to McAllen Care Providers.
Okay.
And that, you know, Mr. Hinojosa and I can talk about that issue, but at the end of the day, I don't have a problem doing an inventory and appraisement about what the community and separate property is, but by definition,
A corporation is separate, is different.
it is different. And we can, you know, if you want a memo on that, we'll send you a memo that it is not separate or community. It is its own entity, and is just now being brought into this lawsuit.
Okay. Judge, Mr. Flores and I have argued this issue before on alter egos, Judge. They provided us the discovery, and based on the discovery that was provided to us, there's clearly no issue that this corporation is an alter ego of their client. Based on the documents from Secretary of State's office, also based on the interrogatory responses of Mr. Navarro. But it is not set for today, Judge, but I do believe that the court can under 6.502 can basically include this part of the inventory and appraisement. It does specify.
Well, because it's not set for today, we'll let it go for another day. Let's just do what's community and separate, but not including the corporation. We can do it at a separate time.
Judge, if the court basically does find this is an alter ego of Mr. Jesus Navarro, then is the court going to reconsider basically doing an inventory and appraisal as to the corporation?
Yeah, at another hearing, if the court considers that, yeah. It can be reconsidered.
Yeah, and Judge, we're a long way from there. You know, we're going to have our special exceptions that we're going to be filing. We're probably going to file a motion to sever. You know, we not want this claim addressed in this issue. This is a whole different issue, but we'll cross that bridge when we get.
I think, yeah, we need to wait on that. Yeah. Right. But in the meantime, let's get Lucy Thompson here as the mediator.
Yes, sir.
And,
yes, Judge.
And try to work mediation here. Okay, get a date going.
All right.
All right, Judge.
All right,
Judge.
All right.
And I'll prepare the order. I'll prepare the order for the inventory and appraisement, Judge, and the order for the mediator. Thank you, Judge.
All right. Thank you very much. Have a big excuse. Have a great day.
If you'll send it to me for signature, please.
You bet. No problem at all. Thank you.
All right. Thank you, guys.
You bet.
Have a great day. Bye-bye.
Thank you.
Thank you. Next.
We have Mr. Julian Rodriguez, number 10.
Number 10.
I don't know if his client is in his office.
And what is it about? Let's see. File divorce. All right. Mr. Rodriguez, can you hear me? Mr. Julian Rodriguez. Is that another case?
Ms. Vela has number 13 and 14.
Uh-huh.
It's temporary orders. Mr. Jason Alanis was served.
Okay, there's Mr. Julian
on
Rodriguez.
9/3.
Good morning, Mr. Rodriguez.
Good morning, Judge. I'm here
Okay, great. Your
With my-
client,
with my clients right here, Judge.
oh, okay, very well. What number is it again?
Number 10.
Number 10, let me see here. Court will continue here with the September 15th, 2022 docket. Next, F2007-22-4 in the matter of the marriage of Antonia Ovidio and Juan Abel Salazar. All right, let me see here. And that's your client right there, right, sir?
Yes, Judge.
All right. Court will take judicial notice of the entire file. And let me go ahead and swear in your client. Good morning, ma'am. Would you please raise your right hand? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you may put your hand down. And Mr. Rodriguez, you may begin.
Your Honor, we asked the court to take judicial notice that we filed a divorce case. The respondent was served. And if the court will look at the final answer that he filed or the response, you will see that he doesn't appear to have any objection to us moving forward with the case today.
All right, court will take judicial notice of the entire file.
Judge, for the record, Miss Antonia Oviedo, will you please state your full name?
Antonia Oviedo.
And you have been domiciled of the state of Texas for the preceding 6 months and a resident of the county of Hidalgo for the preceding 3 months before we filed this divorce case, correct?
Yes. Yes.
And your date of marriage, it was you were married on November 11, 2020 and separated on December 2nd, 2020. Isn't that correct?
Yes, it's correct.
And you're asking the court to grant you've reviewed the decree that I prepared and we filed with the court, and that is your signature on the divorce decree, correct?
Yes.
And you understand that there is no children of this marriage and you're not expecting any children, correct?
Yes.
And you understand that the only property that you had is separate property, which is the house that you live in and the lot located next to the house that you got by inheritance, correct?
Correct.
And you're asking that remain your separate property as part of this divorce, correct?
Yes.
And you understand that when you married, your husband brought nothing into the marriage, you didn't acquire or accumulate any community property, correct?
Correct.
And you understand that you're asking the court that to grant the divorce because you've already divided anything that you may have to divide, such as personal property in this case, correct?
Yes.
And there are no debts to be included in this divorce, correct?
Yes.
And you understand that you're asking the court to grant you a divorce based on cruelty that occurred on December 2nd, 2020, for which your husband is currently still incarcerated, correct?
Yes.
And you're asking the court for a divorce, correct?
Yes.
I have nothing further, Judge, of this witness.
All right, court will hereby dissolve the marriage of petitioner respondent. Court will grant petitioner orally request to hear in open court. Court will await a decree for signature. Anything else, Mr. Rodriguez?
No, Judge, on this case, I have nothing more. I was going to ask the court if the court could tell me when is the next plea on criminal cases. The
I
next
don't know,
date.
because I don't have that.
We don't know, Mr. Rodriguez, because we have nothing criminally in
Oh,
front of us. Everything's
okay.
civil.
Great.
Okay?
All right, and I have nothing further. May we be excused, Judge?
You may be excused. Have a good day.
Thank you, Judge.
Bye-bye.
You too. Bye-bye.
Bye-bye. Okay,
Number 13 and 14.
13 and 14. Who's that?
Ms. Olivares.
Who's on the other side? We don't know yet.
Jason Alanis was served on 9/3.
Miss Olivares, can you hear me?
Good morning, Your Honor.
Good morning,
I'm on
Miss
the
Olivares.
iPhone. Good morning.
All right, good morning. You're here on F3594-22-4 in the matter of the marriage of Berta Balboa and Jason Lanis.
Yes, Your Honor. I represent the plaintiff, Berta Balboa Alanis.
Okay, petitioner, Berta Balboa. Okay, and what about Jason Lanis? Did he get served or something, or?
Yes, he was served on September the 3rd, 2022.
Uh-huh. Has he made an appearance? Does he have an attorney?
No, that I know of, Judge, but if you can have your bailiff call call his name 3 times because he was properly served, so we can proceed.
Okay, court will note that Jason Alanis is not in the waiting room nor in the courtroom. So therefore, I guess we can proceed.
The only thing that I do want to let the court know is that originally this case was set for Tuesday,
Mhm.
and that is the date that was on the order.
Mhm.
I don't know if he got notice of this.
Okay.
Was that the protective order, Miss Ida, that was said? Because she has a protective order that we have not urged.
Yes, originally, these two cases, the temporary orders and TRO were originally set for Tuesday. But the court reset the docket for today, so I don't know if he got notice of today.
Well,
Can we fi-
yes, Your Honor, if we can go forward, and if he comes up, we'll go ahead and have it a rehearing again, because I'm not asking anything out of the normal. I
Are
just
you
want the
sure,
court to
fella?
know a few things about him.
Okay. No,
No, I'm sure. I'm sure.
No, what I'm saying is, can anybody tell me now? Anybody in I'm shorthanded right now. One of my staff members has COVID, so I'm shorthanded. But I want to know if he did get notice for this today's hearing. And I think she's got her hand up, Miss Balboa. Yes, Miss Balboa.
He's aware that it was switched to today.
Have you been talking to him?
No, but I did send a message just to be courteous to let him know that it was changed.
Yeah. And when did you do that message? Do you remember?
That's that same Tuesday.
Okay. Okay. And between that Tuesday and today, you haven't heard nothing? Okay. Shant.
Judge, I sent out the emails, I believe, last Friday.
Okay, here it is.
Yes, Friday, September 9th at 3:46. However, I did not have any information for Mr. Jason Alanis. So notice was only sent from our court, was only sent to Ms. Fela Olivares.
Oh, okay.
And Your Honor, I'd like to respond. Your Honor, I'd like to respond. He knew
Yes,
that
go
he
ahead.
was set on that day. He knew that he was set on Tuesday, and he didn't show up. My niece, Ms. Balboa Alanis, sent him a text, so he had notice after the service, because that's all it's required, notice, not to go serve him again personally. I think he had because of his background, Judge, he has a history of 4 DWIs, and they're in your court. And that's the only thing I'm asking is just to have temporary orders to.
You just said something horrible. He's got DWIs in my court.
Yes, but DWIs are in your court.
Oh my God. Well, now
the fourth one that you got.
Well, forget if it's 1, 2, or 4. The thing is, it's in my court, and I can't hear his civil cases anymore.
I didn't know that, Judge.
Yeah, I think we're gonna have to transfer to another court.
Well, that's what my niece told me. Let me ask her. Are you sure, Bertita, that the cases are in this court, in County Court 4?
That I do not know.
I can get the docket.
I thought you said it was in the same court.
No, I do not know what court he's in.
Okay, what is his date of birth?
I have it in my file.
March 31st, 1982.
3/31/82.
Yes.
Okay, we're gonna check quickly.
Okay.
Okay, we're gonna boom pause. We're gonna check quickly.
Okay.
In the bank. Okay.
Nunca va a acabar.
What's the verdict?
Did you find him, Judge?
Yes, I think we did already.
What court is it in?
Judge,
Yes.
is it Jason Morales Alanis?
Yes.
Okay, I have two cases in county court number 2
Mhm.
and one in a felony court, an I case, and one in our court.
Okay.
But I am showing
You can
disclosed.
transfer that one, Judge, to county court too, because they'll all be over there. Yes, I don't want to be transferred to no judges. Only
Okay, no, but the thing is, which got filed first? That's the issue.
The criminal case.
It's a criminal case, right?
Yes.
Well,
Yeah, it got filed
the-
first.
the-
You know, you can have a civil
the
and criminal.
county court too. The
Yeah, and
county
which
court
one?
too was the first one.
No.
In our court.
So
Yeah. So you're okay. Hijo,
well, do you want to, if county court 2 is first, then they're gonna go that way, the criminal cases. And
But
you
it's
only have
not-
one, so,
But it's not that, Fela. It's what case was filed in our court first.
First,
Is it the
yeah.
criminal case or the family law case? And it's
Right.
the criminal case.
yeah.
The family law
I don't
case just got filed 15 days ago.
Look, what we need to do is reset this one here. In the meantime, it might give us a chance to see where this case is going to end up, either with me or we can probably give it to court too. And I'll let you know.
Judge.
Let me work on it.
Yes, either court 2, if you're gonna give this case, then give it to court 2 or
Yeah,
court 6.
Let me work on
Go
it.
to Maderi and all that stuff, and then she appoints some other judge.
No. It'll be one of those where it's going to stay with one of our courts. My case, if it goes away, it'll go to one of the other courts. Without
Okay,
Maderi.
well, if you,
But today,
you
let's
send-
not do nothing out of the abundance of caution and reset
All
it
right.
again. And we'll let you know what we're gonna do, okay?
And
need
what
an
we
order
did, we
extending.
filed an extension. We
Yeah,
filed
we need
an
a-
extension, so
Yeah,
the
give me
court
an
can
order.
grant that extension.
Yeah, we'll grant the extension. Okay?
Okay, and then I'll talk to Miss Ida next week and
Okay.
see if you're gonna keep it or go to.
Yeah,
county
we'll see
court
what
too,
happens. We'll see what happens, okay? Okay,
Good,
nice
good,
meeting
good.
you, Miss Balboa. Okay, thank you, ma'am. Bye-bye.
Thank you, Your Honor.
Thank you, ma'am. Bye-bye. Okay, what do we have?
Bye-bye.
I need to know what case Miss Patty Love has.
Well, let's ask Miss Betty Love. Here, Miss Love, good morning. Can you hear me, Miss Love?
Now I can hear you. I'm sorry. It's
Great. Which is your case?
Your Honor, I'm here on F 4675-20-4. It's
Over here, number 15.
Estrada versus Estrada. I'm here as co-counsel to Hector Bustos.
There's a
And
motion
then
for
Florencio
continuance.
Lopez came in on the other side.
He filed.
Okay, we
Who's
have
on the
a,
other side?
who's on the other side? Is it Hector Bustos or?
So Hector Bustos
for
is
Hector.
on my side. Florencio Lopez came in for Juan Ramos.
There's
Ah.
a motion for continuance. I don't know who filed it, but there's a motion.
Yes,
Oh.
and I did tell him, I said, look, Florencio, this is the only issue that I have with the motion for continuance. The mediated settlement agreement was already signed since November of 2021.
Uh-huh.
And so they never prepared or no
A decree?
prepared a final decree to enter judgment. And so when I came in, I said, okay, well, let me get this done because the benefit of not submitting a final decree to the court is that child support's never going to start.
Exactly.
And so my client, who I'm doing this case for pro se, had come in and said, you know, I really need help because I'm not getting any help with the children. Like he didn't even want to buy pencils for the first day of school, like nothing. He doesn't want to help,
Right.
and he doesn't want to pay the child support.
Because there's nothing in
And so
writing.
I would think that that the continuance is for nothing else than purposes of delay of the agreed final decree. I did prepare an agreed final decree
You
that
have it
I
already?
gave to Juan Ramos, and then he fired Juan Ramos and then hired Florencio.
Well, submit it. We need to have something signed, okay?
Okay, I will
So-
submit it to the court. I will e-file it right now along
Yes.
with the exhibit of the mediated settlement.
I'll put here decree to be submitted,
Yes.
okay?
I will submit it to the court right now.
Okay, that'll do it. Thank you, man.
Thank
Have a
you.
good day. Bye-bye.
I have Mr. Juan Guerra and Konecki.
Who?
Konecki.
Okay.
Number
Number one,
number 4
number 4,
and number 5.
4 and 5. Okay, we have Mr. Guerra and Mr. Konecki.
Yes, Your Honor. I
Good
also
morning.
have, good morning. I also have there you go.
Oh, Miss Brown,
Yes, Your Honor.
she's your co-counsel?
She is my witness. And
Oh,
a
your
part-
witness.
And
Okay.
my client.
Okay, Penny Brown. We got Penny Brown. Okay. Can you hear me, Mr. Guerra? You need to unmute.
Yes, sir, I can hear. Good morning,
Where
Judge.
Penny went. She
Okay,
logged off.
Penny just logged off, but maybe she comes out and we can probably bring her back in. So I think we have Mr. Guerra and we have Mr. Konecki on CL 22-3719D. Juan Valdez versus Penny Brown and Wendell Curry.
Yes,
Okay.
sir.
All right.
It's my motion, Judge. Judge, I have filed a motion to transfer to the 90 or
93rd?
The 93rd. The problem is not so much with in this case the people that are trying to do the TRO, or I mean the foreclosure. The problem is that COMEX have went ahead and did file numerous lease pendings on property that doesn't even belong to them. That's why we filed a lawsuit, including COMEX. If you notice there, it's also because he's the one that's filed the lease pendants, and without the lease pendants, we can't sell these properties, and they're ready to pay them off. But like I said, it's not too much with the parties that are trying to foreclose, and so the reason that we're asking that it be moved to the 93rd is that COMEX, Judge Mancias, had already a lengthy hearing on all the properties that COMEX has an interest in, because they've been at it for 10 years, buying and selling, and the one that was financing them. And at the end, they made a hit and made a list of all the ones that at the end of the hearing, they agreed this is all the properties that COMEX has an interest. And I gave us that list yesterday to council, and I said, look, if COMEX doesn't have an interest, here it is. This is what Judge Mancias has ruled and agreed. And so they keep on, at the last minute, COMEX filed lease pendings on all the properties, including this ones. And so that's why we included COMEX. And that's why I was saying to go ahead and send it to the 93rd. I think this is the same. This is about the third case that we had in different cases. Yesterday we had this with another judge, court number 9, same situation, but I think council went ahead and we agreed to move it to Judge Noel Gonzalez, again, for the same reason. So I don't know if he's in agreement to move it to what we did yesterday, or how he wants to proceed, opposing counsel.
Yeah, Your Honor.
Yes, sir.
If I may just give you a brief history. We believe that this case was filed, and numerous cases like it were filed in order to conceal a scheme of Mr. Valdez and the Mr. and Mrs. Rodriguez and Mar Design. This scheme has affected numerous lenders, including my client, has affected the title companies, and has affected a lot of third-party buyers in this county. This scheme is evidenced in almost every court in this county. There is a case pending regarding something that these people or related people have done in building this scheme up. Mr. Guerra is right. The two cases we had yesterday, we did agree to transfer those or consolidate those, not transfer, because there's not a legal mechanism to allow us to be able to transfer from county court to a district court. But we agreed that, subject to the 370th accepting the case, that we would have those consolidated. The reason we agreed to that is because the lots at issue in those cases are at issue in the 370th. The lot here today, lot 67, has nothing to do with COMAC. Mr. Guerra, I believe, is mistaken when he says lot 67 is in the Liz pendants that he refers to. It is not. It is not in the Liz pendants. The only lien that is against the property right now is my client's. So there's no relation to COMAC in this case. There's also not a proper mechanism. We're objecting to the motion to transfer. And if the parties object, then there's not a legal mechanism for
transfer.
Your Honor to transfer it. They chose to be in county court at law. They got the case submitted to Your Honor. And now they're asking to get out of Your Honor's court, which they cannot do. We are here today. We're ready to move forward. I want to be very clear that lot 67 has nothing to do with COMAC, even though Mr. Guerra has included them in this lawsuit, that he hasn't served them. He hasn't moved forward with that. But it's not included. You can look at his own exhibits. It's not included in those Liz pendants, and there's no relation to COMAC. So in addition to there being no legitimate or legal avenue to be able to transfer this case, Your Honor. So we would ask that the motion to transfer be denied.
Okay,
Your
and
Honor,
yes, go ahead.
Your Honor, if counsel is correct, and because we did file on the motion that the reason we having problems because of the lease pendants, but if counsel, because COMAX just went ahead and just, I just went on and on and on and did, I don't know how many, at least 100 or so. But if he said, if counsel has saying that there's no lease pending, that he already checked the list and this is not there, and then I'll go ahead and agree to, I guess, dismiss based on his interpretation that there's no lease pendings from COMAX. And if that's the case, and then we have no reason not to pay him. That was the only reason that we were not able to clear this debt. So I guess if based on his word, I don't see why he would. If we find out it's different, then we'll obviously address it at that point. But I'll go by his word that COMAX did not file the lease pendants on this property, and so that basically go ahead and deny the and we'll dismiss the case and then try to pay off with the opposing counsel as per the debt that is owed. The lease pending obviously was the one that was constant. We don't have a scheme. The scheme is basically COMAX is the one that's keeping us from doing this. But if, like I said, if counsel says that COMAX did not file a lease pendants on this property, and then there's no reason for us to have a TRO, Your Honor.
Okay, now, first of all, the court will deny the motion of transfer. And Mr. Koenke, what is your response?
Your Honor, my response is the TRO and the TI, the temporary injunction should be denied because there's no evidence of irreparable harm. There's no evidence of a cause of action.
Okay.
You can disregard my statement about the list pendants or not. It's accurate, but even if I hadn't said that or made that representation, there's no evidence that would support a temporary injunction. All my client is trying to do is exercise her right to foreclose on the property. And that's what we're asking Your Honor, to deny the temporary injunction. If he wants to dismiss, he can do it however he wants to, but today we would ask that the temporary injunction be denied. And I would state that if later on down the road, when we post again and it goes up for foreclosure, if Mr. Guerra or his client decides to file again against Mrs. Brown, that he know that I represent her. And so this whole thing about ex parte TRO and all that, I mean, that could cut down on a lot of time, a lot of attorney's fees, and a lot of cost, Your Honor.
Yeah, he should know that you're the lawyer now. Okay.
And so
I have no problem, Judge, doing that.
Okay.
So moving forward, if Your Honor would deny the temporary injunction, we can move forward.
All right, it'll be denied.
Just to keep it on the deal, Judge, why don't you just give us a status date just so that so it doesn't linger. I'm gonna check to make sure that there's no lease pendings, and we're gonna move to dismiss. But I guess for right now, at least give us some sort of.
Well, just submit an order for status hearing, and we'll probably do it down the line. But for right now, the temporary injunction is denied, and the motion transfer is also denied. Okay.
Okay, thank you, Your
Thank you,
Honor.
Your Honor.
All right.
He
All
also
right.
has number 3. Forgot.
Okay, thank you, Mr. Carnegie. Thank you, Ms.
Thank
Brown.
you.
You may be excused. Thank you.
Thank you.
Have a good day. Mr. Guerrero, you have another case, right? Is it Jose Luis Reina versus Connie Cub? CL 221575D. Jose Luis Reina versus Connie Cub. You remember? You're muted.
I thought you could read lips, Your Honor.
Now I can hear you.
I was just telling you that it looks like it was moved to federal court about 2 days ago. I checked, unless I'm mistaken, but so that got moved to
federal court.
Federal court, yes, sir.
I'll take your word for right now. We'll write it down here, okay?
Okay,
Okay, anything else? I think that'll do it, right?
that's all I have, Your Honor.
Thank you, sir. Your excuse. Have a great day.
Stay safe, Judge. Bye.
You too. Stay safe.
Okay, number 9, Mr. Arturo Garcia is there in the courtroom.
All right.
His client
All right, let's
is
do it.
connected.
All right, let's do it right now. Mr. Garcia, can you hear me?
Yes, sir.
All right, there you go, man. Thanks to technology, we can have court anywhere, in your car, in the courtroom, in your house. Okay. You have F 1933-22-4 in regards Alan Camberos.
Metals, yes, Judge, that is correct.
All right, Camberos. Okay. And you're seeking, you have an applicant who is seeking a name change, right?
Yes, Judge, that's correct. And I believe she's present on screen.
Okay. You want to put on some testimony?
Yes, Judge, of course.
Okay. Please raise your right hand, Ms. Camberos. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
You may put your hand down, and Mr. Garcia, you may proceed.
Okay, Jade, can you please tell us your full and complete name?
It's Alan Javier Camberos.
Okay.
And you also go by?
Jade Camberos.
Okay, and what is your date of birth?
12/18/03.
And what city do you live in?
Alamo, Texas.
And your place of birth?
McAllen, Texas. Mission, Texas. I'm sorry.
Okay, and your gender at birth?
Male.
Okay, have you ever had a FBI number or state identification number for a crime?
No.
Is there any pending investigation, state or federally, against you?
No.
And have you ever been charged with an offense greater than a Class C misdemeanor?
No.
Are you the subject of any felony conviction?
No.
Have you ever been arrested?
No.
Okay, are you the subject of any sex offender registration requirements? So no criminal history whatsoever. I think it cut off there. Was that a no?
No. Yeah.
Okay. And for the name change, what is the name that you're requesting the judge to legally call you?
Jade Camberos.
Okay, no middle name.
No.
Okay. And I believe you had submitted an affidavit. That should be on the record, Judge. It should be with the court documents already. In that affidavit, that was your intention of requesting the judge to allow and grant the name change.
Yes.
And you recall that affidavit? You remember that affidavit? It was a while back.
I think so, yes.
Okay, I just want to make sure. Okay, and how do you presently identify yourself? Male or female?
Female.
Okay. And I believe, well, do you feel that changing your gender from male to female is in your best mental interest?
Yes.
Okay. And let's see. Well, are you asking the court to grant the name change along with the gender change?
Yes.
Okay, great. Thank you, Jade. Jade, I have no further questions, Judge, unless you have a question.
Okay, I'm sorry. The first name is Jay or Jean? I didn't get it.
Jade.
Oh, Jade. Jade?
Yes.
Okay, I got it. Okay. All right. Court will take judicial notice of the entire file in cause number F 1933-22-4 in regards to the application of Ellen Camberos Court will hereby grant petitioner or applicant or relief request to hear in open court. And court will await a judgment for signature. Okay, that'll do it. Thank you very much. Y'all excuse. Have a great day.
All right, thank you, Judge.
Thank you. Bye-bye.
Thank you.
Thank you.
Yes, Alma Garza, number 11.
Number 11.
That's the last one for 10 o'clock.
You can see 11.
11, yes.
Ms. Garza, can you hear me? Or she's connected? Good morning, Miss. Miss Alma Garza is connecting. She's next.
That's number 11.
And number 11. Okay, we're waiting on Ms. Garza. She is connecting right now. That's the 11 one.
Judge. Ms. Garza is in County Court 10 and in the 93rd. She's trying to finish up, but I did tell them that we have it, the Zoom is available here, so she might be coming into the courtroom right now.
Okay. Okay.
The
And if she
client,
doesn't,
her client is at her office.
okay. And if she doesn't make it by 11 or 5 minutes till 11, like in 5 more minutes, I think we're gonna have to. No, it's already. Yeah, in about 5 minutes, I need to log off and get into my 11 o'clock.
Okay.
So even if that happens, you gotta tell her to wait there in court or something and see how
Okay.
we can remedy her situation because we need to get ready for the 11 o'clock.
Yes, sir. Okay.
Okay.